I want to welcome you and thank you so much for getting dressed and leaving your home offices to attend what is our 4th annual, wish it was our 6th annual, program in which we ask Jeff and Erin, two brilliant constitutional litigator scholars, to help us explore what's important from the Supreme Court's criminal law docket. I think this is the only event that is like this, and obviously also the best, but it's also the only. My vision in creating Due Process Institute was a simple one: to create a bipartisan policy shop to preserve procedural due process rights in our criminal legal system through any means necessary: legislation, litigation, public education. It's premised on the belief that regardless of our collective political beliefs, or however bitter the partisanship is in town, that there are fundamental principles at work in our criminal legal system that we can all agree on. I happen to think that this program is a good example of that principle at work. We consider ourselves first and foremost lobbyists for the Constitution, and we employ lawyers, advocates from both sides of the aisle. In fact, I'd like to point out Jason Pye. Jason Pye, wave, stand up and wave. Woohoo! He is our Director of Rule of Law Initiatives at Due Process Institute, and he was, importantly, one of the principal architects behind the passage of the First Step Act, which, for those of you in the room who have had clients helped by that, you can thank Jason on your way out the door. Many others obviously worked on that legislation, the federal defenders in the room, but Jason truly was one of the principal architects. And so thank you. And if you don't know what the First Step Act is, ask him why it's the most meaningful criminal justice reform legislation to have been passed in 10 years. But we aren't just lobbyists. We are also pursuing our criminal justice reform objectives through the creation of cutting-edge research and scholarship, and through the strategic filing of amicus briefs. Our sister organization, Clause 40 Foundation, which is a newly minted 501c3, we just received our status a few days before COVID hit, so this is really its sort of public debut as an organization, that it engages in non-lobbying policy and litigation advocacy work. And to that end, I'd like to introduce its only current employee, Carolyn Iodice. Where are you? Where are you? Stand up, wave, everyone, hi. Senior counsel at Clause 40 Foundation. She was actually an instrumental part in helping me to create the sarcastic but very informative brief guide to SCOTUS's criminal law stuff that's included in your CLE materials. It's brief because it is only 30 pages, 1.5 times spaced. You should actually read it, because every year 5 or 6 people do, and they take the time to email me and tell me it's brilliant and funny. So actually, maybe check it out when you are on your next flight. At Due Process Institute, and now at Clause 40 Foundation, our mandate, our passion, is to honor, preserve, and restore principles of fairness in the criminal legal system, like abolishing acquitted conduct sentencing, reforming the criminal discovery laws, bringing accountability to the prosecutorial function now, not 10 years from now. In the 4 short years in which we've been in operation, we have drafted, introduced, and passed meaningful criminal justice reform laws. We have filed dozens and dozens and dozens of meaningful amicus briefs, some of which have actually been on the winning sides. And we have educated hundreds of people on a variety of critical issues that need attention. But here's the hard part to say out loud to all of you, but I'm among friends. COVID hit us hard as a brand new organization, not being able to travel to meet new people, to share our ideas, to spread our name, to create new partnerships with funders, to hold fundraising events. All of that, it's had a severe impact on our budget. We are incredibly grateful to the law firms that generously partnered with us to sponsor this event. But that support doesn't go far enough to even cover the cost of this event, an event we continue to pledge to put on for free so that everyone who wants to be here can, including, we always have dozens and dozens of public defenders who come here. We also desperately need more funding to expand our staff. Just ask Tamara, who you met while coming through the door, who has at least 4 different job titles, or Trey Brown, who's hiding over here in the corner. Stand up and wave, Trey Brown. He does the work of 6 people. He is actually a policy associate, yet he's figured out how to try to record this event today. I'm just going to say, if we don't get more staff resources, these people are going to quit. Or worse, they're going to stay because they love their jobs and they find our work meaningful. But they're going to continue to work the jobs of 5 and 6 people for an eighth of the pay. And that isn't good enough for smart, awesome people who are deciding to dedicate their work and their life and their time to nonprofit work. So help me make their lives better. I'd like to ask each of you, if you're getting value at a program like this, or if you support the work we're doing in Congress and in the courts, please take 2 minutes, not even 2 seconds, to support our work actually right now. And we have tried to make it easy for you. When you came in, you saw the cards sitting on your chairs. These have fancy little QR codes, which I know everyone knows how to use because you've been to restaurants and this is how you get the menu post-COVID, right? So we've been forced to figure out QR codes. This will take you directly to where you can make online donations. If you donate with this card, it's tax deductible and will not be used to support our lobbying work, but it can be used to support an event like this, in fact, or our internship program, and you can pick where you want the money to go. If you do want to support our lobbying work, which is really, really, really important, but the government doesn't think it's important enough to give you tax benefit from it, please use this card to donate. Or if that's too difficult to do, or you don't feel like doing it now, go to our websites, find the info there, or you can just hand me cash on your way out the door today. Thank you in advance for your donation. Please know that money isn't the only way we would accept your help. We have amicus requests pouring in from across the country. We've turned down a lot of good ones. Heck, even I'm sure that sometimes I don't even have the time to respond to all of the requests, which isn't good, but we don't have the staff to even respond to all of them because we are severely understaffed and don't yet have the resources to say yes as often as we like. If you want to write amicus briefs for us on a pro bono basis, please sign up at the door. I'll reach out to you. I'll find out what issues mean the most to you, where you'd like to be put to use. And trust me, we will be putting your time and talents to use. All right, just a few housekeeping notes. If you need CLE credit, if you were from New York, you needed to have signed in when you came in. And then everybody who wants CLE credit needs to sign on the way out. Ritz hammer on the front. If you didn't do that before, make sure you do it right now. Once CLE applications are granted to us, we will be emailing you your certificate. So please, and this is important, people, because this happened last time we had this. If you didn't give us a good email address when you registered for this event, you gave us the fake email address that like you never ever check, please stop by on your way out the door and tell Tamara that and give us your real email address that we can mail your CLE certificate to, because we don't want your CLE certificate sitting in a box for a year while you're saying, I don't know why I haven't heard from those people yet. All right, we're going to give you a couple more minutes to get through your delicious meals before we ask Jeff and Erin to come up here today. Thank you so much for being here to help us celebrate Constitution Day. Nerding out on the Constitution might not be everybody's thing, but it's clearly your thing, or you wouldn't be here among us. So welcome, enjoy your lunch, and be prepared to have your minds blown by Jeff and Erin. At some point, maybe sooner rather than later, we will need additional Supreme Court justices, and I submit that we need look no further than the affable and talented lawyers who have joined us today. Please join me in profusely thanking Jeff and Erin for joining us, and please also join me in thanking our sponsors who did help us put on this event today. Blair Brown from Zuckerman, thank you, sir. Barry Boss and the friends at Coase and O'Connor, thank you, sirs and madam. How's you doing? The folks here in the front, thank you, thank you, thank you. And Miller and Chevalier, who is my husband really the only MNC lawyer who made it? Everyone else had a client emergency. Is there someone else? That's it. At least my husband showed, so there's that. He landed from a flight in Amsterdam last night in time to get here for me. So thank you. I appreciate that. And now I'm going to actually give them the honors of introducing them, our two brilliant lawyers. So take it away. Why don't you go first?
Hi, my name is Matt Kaiser. I am beyond excited, like wet your pants excited, to be able to introduce Professor Jeffrey Fisher. Even though I just met him right now, I've known about him back since I was a federal public defender in Maryland, and Crawford came out. And of course, for folks who I'm sure everybody knows, but Crawford stands for the remarkable proposition that when the Constitution says you have a right to confront your accusers, what that means is that you have a right to confront your accusers. And it took, really good advocacy to get us there. When that came out, like in the office, it was like each one of us had a new iPad. It was this great toy we could play with to make prosecutors' lives miserable. Yes, of course, we're going to trial and it's a drug case, and I know you've got a lab report, but we want the technician there. I can't cross-examine like a bag of cocaine, or maybe cocaine, in a piece of paper. We get a person. And the prosecutor would say, but Judge, this is really inconvenient. And the judge would say, yeah, but the Supreme Court's got this. What are we going to do? It was a great day for public defenders and criminal defense lawyers generally, and it made prosecutors' lives immeasurably worse. And if we can agree on one thing today, it's that making prosecutors' lives immeasurably worse is a good part of what justice is. I remember yeah, exactly, yes. The next big Washington State case came out, right? Blakely, and of course Blakely just says if you're going to raise somebody's sentence based on some fact and it's mandatory, then you got to have a jury make that determination. And I remember where I was when I heard that Blakely came out. I was in Marshall's lockup at the federal courthouse in Greenville, and I walked out from seeing a client, and a friend of mine had come in and said, hey, they just decided the guidelines are going away. We have vanquished the guidelines. And because, I think, right, like Booker just kind of deductively follows from Blakely. And of course, it turns out that the guidelines are sort of like Jason from Friday the 13th, right? They keep not having been vanquished, but they're a pale shadow of what they were. And that's because of Professor Fisher and his amazing work. And then the last case I want to talk about, then I'll sit down because they're more interesting than me, is of course Riley versus California, right? Like Riley is a great case for all of us. The police cannot search your phone unless they've got a warrant, generally. When you think about all the stuff on your phone, like I don't know if you guys are like this, when I think about my browser history on my phone, I am incredibly grateful and excited to have, you guys know what I mean, but Barry Bloss, you're there with me, right? It is a win for all of us, and it's not an obvious result. And I'm really excited to listen to Professor Fisher talk about the Supreme Court's criminal docket, and so grateful that this organization's here and our event is here today. Thanks. Okay.
So good afternoon, everybody. I'm Tim O'Toole, as I think Shana mentioned, and I'm here to introduce Erin Murphy, and I am very excited about it. I was going to say that I was as excited as Matt was, but then he described how excited he was, and maybe I'm not that quite as excited, but I am very excited, and here's why. This is a criminal law group, so you may not have heard as much about Erin as you have about Jeff. But Erin Murphy is a really big deal. The current president might even use different language to describe what a big deal she is. She is the founding partner of the law firm of Clement Murphy. It's been around for, I think, about 3 months at this point, but it's already up to 11 lawyers. They have clients lining up to represent them. She is a huge deal at the Supreme Court bar. She has done a number of cases this term and many terms that you will have heard of. She clerked for the Chief Justice. She clerked for Diane Sykes of the Seventh Circuit. And if you're talking about Supreme Court practice, I can't think of anybody that you should hear from besides Erin and Jeff. So I'll turn it over to you guys.
Well, I'll just say a quick thank you before we start the actual program to Shana and to everybody at DPI for hosting the event and putting it back together. These in-person events, I think for a lot of us, mean even more than they did before COVID. And so it's wonderful to be with all of you. And At the same time, it's sometimes a bigger ask in the post-COVID world to, for those of us that now maybe work at home some days or that getting out like this isn't as easy. So coming here, I think means extra amount to all of us, to Erin and I and to DPI. So thank you. And the fact that I'm here just is hopefully just my own 2 cents to show that how much I believe in this organization and what it does. Thanks a lot. And I'll hand it off to Erin and share whatever initial thoughts, and then we'll get into our program.
Yeah, no, I just also want to echo the thanks, especially I think you all get extra credit for being here inside for this on one of like the nicest days we've had yet so far in DC. So hopefully you'll all get a chance to go do something outside later today. But it is really wonderful to be back here with everybody after a few years and have a chance to be talking about a lot that's coming up, a lot that's happened. And both in terms of cases, and I mean, I think the court has changed multiple times since we last did this event. So there's just a whole lot going on in the Supreme Court generally, and in the world of criminal and due process law in particular. And we're both very excited to be here and talk with everybody about it. We thought we'd kick things off by, we're gonna talk a little today both about what's coming in the next term, but also a little bit more looking back, in part because we haven't been able to do this event for a couple of years. So we thought we'd talk about some of the cases that we haven't had a chance to talk about with all of you guys, and take a little bit of stock of kind of what we know about this court now and where we think they're headed. Both in specific ways, but just a little more big picture. So, I'll kick off with just a few thoughts about the most recent term and the court generally before we get into specific cases. And obviously Jeff jump in with his own thoughts about all of that. But I mean, it's hard to. I know we're here in particular to talk about due process and criminal law, but it's a tough moment in time to not recognize that we're coming off just a truly historic term by any measure at the Supreme Court in terms of cases that were decided. You have the court putting out the Dobbs decision, Roe. You have the court putting out the Bruin decision, which was not only a huge Second Amendment decision, but also a decision that really kind of laid out what I think we all think reflects sort of the way this new majority of the court thinks about the Constitution as sort of a writ large manner. So, there's just a whole lot to think about as we're trying to process, with a court that is not even going to be the same membership this term that it was last term, exactly what the court at this point looks like. And I'll offer 2 observations at a very high level. I mean, first, I think there's no denying at this point that we have a court with a true conservative majority, with a 6-3 conservative majority. It is, that said, I don't think it's a monolithic conservative majority. We've also seen already that they're not in lockstep on everything that comes before them. And if anything, some of the cases that are of particular interest to DPI folks here today may be areas where we're actually going to see a little more division among the court, among the 6 conservatives, and a little bit more a little bit stronger libertarian streak from someone like Justice Gorsuch. You definitely still have a much more of an order streak. Somebody like Justice Alito. You have some newer justices that we're still kind of fully assessing where we land between those 2 dynamics. So, so I think I would offer this caveat about a whole lot of areas of law, but particularly when it comes to criminal law and due process rights and criminal procedural rights and all of that. I don't think that knowing that we have 6 solid conservatives and even 6 solid conservatives who are pretty comfortable moving quick, taking big steps in the court necessarily tells us, what to expect across the board in a lot of the cases that will come up before the court involving criminal law rights and procedural rights. But I do think that we can take a lot from not just from the Bruin decision, but across a number of decisions the court put out last term, where this majority is very, very focused methodologically on the idea of thinking about the Constitution through a lens of text, history, and tradition. You certainly see that laid out, most in its most elaborate and really kind of first principles defense form in Bruin, when the court had the opportunity to decide, on a clean slate, how are we going to think about constitutional analysis, and said, in the Second Amendment context, we're not doing any of these tiers of scrutiny, any of that type of balancing. We are going to think about interpreting the Constitution through the lens of text, history, and tradition. And oh, by the way, we are even going to tell you that's how we think we do it most of the time, which may or may not be true across the board. There are certainly some provisions where the court has been doing that. There are certainly some where it has not. But I think that is laying down a marker that is not a decision that is just about some kind of, okay, we're gonna have some rule for the Second Amendment. You can really see that commitment to text, history, and tradition in the way the court thought about Dobbs, in the way the court thought about things like the Establishment Clause cases it had before it last term. And in Bruin itself, the court specifically highlighted criminal law as the kind of a lot of issues in the criminal context as areas where it thought the court has more traditionally been focused on text, history, and tradition. So I think that is just an important thing for everybody to think about in litigating going forward, is that you're going to have to think a little bit more about how to frame issues in that manner, especially if you're teeing them up in the long term to try and get a favorable resolution of them from this Supreme Court.
Well, those are great thoughts. And so I think I'll share a few reflections of my own about the past term before we go back and forth a little bit on themes to watch for this term. So I'll just start by underscoring what Erin said. And big takeaway for me in many ways, and maybe it should have been obvious beforehand, but it's certainly obvious now, is that 6-3 is a lot different than 5-4. A supermajority just functions differently, at least this one does, than the 5-4 court that we were used to for more or less a generation, where a few justices in succession kind of occupied that middle turf, and the court, in many cases, not all, but many cases, particularly high salience cases, publicly would go one way or the other based on a particular justice, and even more, that particular justice might not go all the way in one direction or the other. And so I think that's the first thing that I would amplify about the difference between 6-3 and 5-4 is, if one justice peels off and says, well, I want to find some middle ground, I want to go narrow, take the Chief Justice's separate opinion in Dobbs as an example. I want to uphold the Mississippi law, but I don't want to overrule Roe. Well, that's now a sixth vote, not a fifth vote. And so that therefore has no force of law, because the 5-justice majority can still go big. And so I think many of us might be happy to be relieved of the burden of parsing concurring opinions and the Marx rule and all the rest that we have to do sometimes with these splinter plurality opinions. But in terms of the law, it allows the law to move much bigger and much faster. Leah Littman at Michigan, I think, in her Strict Scrutiny podcast, calls this the YOLO court. And so, in characteristic style, it's a great line, but I think captures something, at least for the moment, that we experienced last year. And the second thing I'll highlight about 6-3 versus 5-4 is that it impacts the court's docket and its agenda setting. As I think everybody knows, it takes 4 votes to grant cert. And so, again, for a generation, one wing or the other of the court has always had the ability to force an issue onto the court's docket. And sometimes that was deployed strategically, and sometimes people would hold back because they weren't sure they had a majority. But especially in a criminal law setting, I want to highlight there's one category of cases over the years that I'm really going to be watching. Now I'm shifting now to the upcoming term a little bit. But if I think about cases in recent years like Flowers against Mississippi, Buck versus Davis, cases that you might think of as sort of egregious error correction cases on the court's docket, that once they get on the docket are 7-2, 8-1, 9-0 decisions. I'm not in the room for any of these cert votes, but based on my experience a long time ago, often it's just 4 or 5 votes that actually get those cases on the docket to begin with. And those cases have very meaningful impact. When Flowers comes down, everybody says, oh yeah, Batson is a thing. We have to pay attention to that. All the way down to the lower courts and state courts in every county in the country. And without the ability of the liberal wing to grant cert in those cases, I'm going to be watching those kinds of cases, which has been an important part of the criminal docket to see whether we still get those kinds of grants in criminal cases, or whether we'll just be focused more just on traditional circuit split kind of grants. The other thing I'll say, and I think this is backwards as well as forwards, is that it's really fun to have this conversation in a criminal law setting. Erin and I have done a fair amount of these events, probably, and in the last 12 months, in particular in the wake of the last term, we're living in an ideologically and politically divided time, and it can be very, very difficult, to have some of these conversations about what the court's done and where it's going. But boy, if there's one space where the court has been a little more harmonious and the temperature seems to be down, it's in the criminal law space generally. And so I view that not just as a welcome relief, but I also view that as real opportunity for DPI, for those of you in policy space, and for those of us who are practitioners litigating the cases. I think this is a moment of opportunity where the Supreme Court and probably others are looking for ways to agree sometimes and to come together and make progress. And I think criminal law could be that space. It could provide that avenue. And so hopefully as we turn to talk at the cases later today, that theme will come through. And, the Supreme Court and optimism, at least in some circles, those two words don't go together that much anymore. But in this room, I think they can.
Yeah, no, I think it's a really interesting question to think about, how to pitch the right cases to get the court to be interested in criminal issues. I agree. I think there is a real dynamic of, the difference between the cert stage and needing the votes to get there and what's going to happen with the case once it's there. I mean, I think a great example of that is the Bruin decision this year, which the court had turned down that issue for about a decade, and everybody thought it's like, some of them are soft and who knows what the vote will be. And then once they were to force the issue up, a solid 6 justices all just completely agreed about an issue that the court had ducked for a decade, and I think that's true, that you have some of those things that once their hand is forced, they're going to be in some of the same place, and there's just a real challenge to figuring out how to learn what any set of 9, what appeals to them and makes them want to take a case. But part of it, I think, is getting them to think about a case as, this is one where you can do some good work and you can maybe get there in a way where you're all a little bit on the same page.
Yeah. Well, if I think about the things that maybe I'm going to try to be watching this term and beyond, I think I'll highlight 2 things. So one is picking up on your point about methodology. I think that obviously the court laid down a very important marker in Bruin about the importance of history and tradition, and strongly signaling we're going to carry that into other spaces. And as somebody who litigated Crawford, for example, it's nice of you to mention. I always feel like it's like the past. I feel like REO Speedwagon up here. You're mentioning like 20 years ago. I'm still riding the wave. But anyways, here we are. But I'm certainly, a supporter of historical arguments, and I think that history has an really important role to play in constitutional interpretation. I think tradition, is a little dicier in some ways. I'm going to be watching. It kind of rolls off the tongue, history and tradition, but I think tradition, if I understand the concept, means post-founding law, post-founding practices, maybe under common law, maybe legislative practices from which we draw inferences of what the sort of common understanding was. That seems to me, if you're sitting in a judicial seat, much more manipulable ground. And if you're sitting in a lawyer's seat, much more manipulable ground that you can work with a lot. And so definitely an opportunity as lawyers. And I think it'll be interesting to see how the court maybe continues to work with that in other areas. And I think the other thing I'll be watching methodologically is in this moment where, at least in some circles, there are real questions being raised about the court's, quote unquote, legitimacy. And I think a feeling amongst the justices, and some of us have just seen this in quotes from the recent circuit conferences across the country where the justices have appeared, that they're listening and they're attentive to these conversations. Whether the court will be looking for ways, again, maybe, especially in the criminal law space, to show that methodologically they truly are committed to following through on history, tradition, text, even in places where it would lead the court to outcomes that wouldn't be so predictable politically. And so whether the court will actually seek out cases that give them those opportunities or just seize them when it finds them, I think that'll be an interesting thing to watch this term. And the other thing I'll just highlight, I think it would be remiss if we didn't mention before we got into the cases that, as Erin noted quickly, we do have a new justice on the court. In a setting like this, we have a Justice Jackson, who is a former public defender and the very first the very first public defender ever to sit on the Supreme Court, which is just a monumentally big deal. I've been at Stanford now for 16, 17 years, and even finding former public defenders anywhere on the federal bench has been woefully difficult, and the message that sends implicitly, I think, to our students when they compare it to the number of former prosecutors on the bench, I don't think is a particularly healthy message. And so I think just her presence in all kinds of ways, but that's one, will be really valuable. But then the more important question maybe looking forward is, do they listen to her? And, I think that, I remember years ago when I worked for Justice Stevens, he told me, told the clerks, that whenever we had a bankruptcy case, we just did what Justice Douglas told us to do. He'd been general counsel of the SEC, and he would just tell us what and we would just kind of go along.
Makes you feel really.
Yeah, exactly. Well, it makes you feel better and worse, right? If somebody has genuine expertise, that's valuable, right? So maybe that's the positive spin on it. But now with her special experience that other members of the court, most of them don't have any criminal law experience at all, and none of them have defense type experience, whether in oral arguments in the conference room or otherwise. She has an impact that is felt that we can see will be really interesting to watch.
Yeah, no, for sure. And particularly, 'cause I do think it's an area that the justices like to fancy themselves all, good enough at, even if they have no experience with it. So it'll be a very interesting dynamic. And as they'll say, anytime you change even one justice, it changes the whole dynamics of the court. So to the extent we all thought we got our hands around the court last term, we got a whole new one to think about already. But.
All right, so we turn to some cases.
Sure.
So our thinking going into this, because we didn't have this program the last year or two, and because the court's criminal law docket has been a little bit light, would be to take advantage of those two things. And so we're going to talk about some cases that were decided the last year or two, and some that we're looking ahead to. So when Shana was giving the introduction, she talked all about how Erin and I are, constitutional scholars and the rest. Which hopefully on some level is true, but it occurs to me that when I looked at the cases, there's very few constitutional cases on the criminal side. The court has been doing a lot more statutory work. But the court has done has decided a couple of constitutional cases that I thought I would just mention first as a way to jump into the cases, and maybe as a way to illustrate some of the things that we just talked about thematically in terms of the justices. So I'm just going to contrast two cases, constitutional cases decided in the past term. One, Vega versus Teco, which is actually technically a Section 1983 case, not a criminal case, but it dealt with the Miranda warnings. And just in a nutshell, the court held that even though Section 1983 provides a cause of action for anyone who is deprived of his rights or privileges under the United States Constitution or its laws, period, people cannot bring a Section 1983 claim when they are deprived of their Miranda right. And the court kind of danced around the head of a pin, saying that, well, Miranda is constitutionally based, but it's not a constitutional right. And so therefore, because it's a prophylactic rule in nature, we're not going to let it be the cause of a Section 1983 case. And without getting into the weeds, I think the takeaway from that decision is that when we find a constitutional right in the criminal sphere, really, or anybody else, anywhere else, but for the people in this room, in the criminal side, that we do not think has grounding as a matter of text and history, we are not going to, we're certainly not going to extend it. And maybe in some settings, you could say we're not even going to enforce it. And so I think rules like Miranda, rules like the exclusionary rule under the Fourth Amendment, certain due process rules the court has created, I think are going to be very, very difficult to get any mileage out of in the Supreme Court. And what we're going to find ourselves doing is simply trying to hope those cases are not overruled. And I want to contrast Miranda. So I said this would be optimistic. I want to contrast Miranda with a case I was involved in last term called Hemphill versus New York, which is kind of the court's latest look at the Confrontation Clause under Crawford. And this is actually an 8-1 decision, but the dissent for Justice Thomas was on procedural grounds. So on the constitutional issue, 8-0, the court held that the Confrontation Clause was violated and remanded for a new trial. Again, a unanimous decision from the court with another criminal procedure right, but one that I think the court feels more comfortable with. And I'll just tell you a little bit about Hemphill, and I don't know if Erin has any thoughts about either of these cases. But Hemphill arises from a drive-by shooting in New York and in the Bronx, and the issue was who fired the gun. And what they knew was that the bullet was a 9mm gun. And so they initially prosecuted a guy named Nick Morris, who they thought pulled the trigger, and who actually had his house searched that day. They recovered a 9mm casings in his house, bullets, and they had eyewitness identifications and the rest. They went to trial, and then ultimately a mistrial was declared, and the prosecution accepted a plea from Mr. Morris for simply being illegally in possession of a firearm. But importantly, at the plea allocution, Mr. Morris was allowed to say that he possessed a .357, not a 9mm, so implicitly exonerating himself from the killing. Years later, the police became convinced that Mr. Hemphill had committed the crime and prosecuted Mr. Hemphill for it. Mr. Hemphill's defense, as you might predict, was the state was right the first time. It was actually Mr. Morris who fired the gun, and so he ran a third-party defense, third-party guilt defense, and included the evidence of finding the 9mm bullet in Mr. Morris's apartment. And at that point, the prosecution stood up and said, well, now, if that's what Mr. Hemphill's defense is, we want to introduce Mr. Morris's allocution. Even though Mr. Morris is not going to be testifying at trial, he's now in Barbados. So we want to introduce his allocution, which, as you all would know, under Crawford, is a classic testimonial statement. So Mr. Hemphill said, well, wait a minute, that violates the right to confrontation to introduce that testimonial statement. And the state said, no, Mr. Hemphill has opened the door to that by running this third-party defense. So he has rendered that relevant, and to prevent the jury from being misled, we need to be able to answer that with his allocution. And the New York Court of Appeals, the highest court in New York, accepted that argument. And the court granted cert, and as I said, reversed unanimously. And what's nice about the opinion that's written by Justice Sotomayor, it's kind of a unambiguous reaffirmation of Crawford after a little bit of a rocky patch, at least in some circles in the court, and maybe some of the new justices have actually shored up Crawford in certain ways, at least the core of it. And the court says simply rendering, if a defense simply renders evidence relevant, that cannot possibly be enough to waive the confrontation right or open the door to the prosecution introducing testimonial statements. And the court reserved the question for another day, which I think was the only hard question in this area. What about for those of you who are trial lawyers, the rule of completion? There is an evidentiary rule that says if you introduce part of somebody else's statement, then the other side can introduce the rest, or the court can force you to introduce the whole statement. So the court left for another day whether you could open the door in that sense. But because Mr. Hemphill had not introduced anything that Mr. Morris had ever said, let alone part of his elocution, that issue was not presented in his case. So a nice reaffirmation of Crawford and maybe an example of the kind of criminal procedure cases the court's going to be receptive to.
Just offer one observation on the kind of constitutional front. I mean, I do think that this court feels, whatever it thinks about the substantive question of what the scope of a particular right is, I think this court feels very differently when that's all arising in the context of suing a government official over it. Then you start to get into the whole world of the causes of action and things like qualified immunity and all of that. And like, I think that is, I mean, it's one thing to enforce Miranda in the context of enforcing it to keep the evidence out. It's another thing when you start talking about what can you do with the Miranda right. And that's where, one other interesting data point on that last year was that the court really, I think there were only 2 summary reversals that the court put out that weren't in the context of cases where they dealt with the Shadow Act. The court got back in the business last term of reversing qualified immunity decisions to say that courts, didn't follow qualified immunity and need to be very strict about needing another case out there that is, about pretty much on all fours in order to impose qualified immunity. And I think when you kind of take all of that together, that we still do, there was sort of a probably the brief shining moment was probably last time we were here, when it looked like, maybe there were some members of the court who were really focused on history and thinking about all of that differently. But I think what we've seen at this point is that this court, across whether in the criminal context or more broadly, has a very different feeling about people turning around and suing the government than it may have when things are arising in the context of the actual criminal prosecutions, which is a good thing to think about, from the perspective of litigators who want to advance criminal law. Like, as with anything, you do have some ability to control how you want issues to get to the court, and issues in the criminal context, getting there in the actual context of a prosecution can sometimes actually be a better dynamic, I think.
Kind of the revolution that wasn't. But I do wonder, the only thing I'll add on that is that I think that just reaffirms for those of you in the policy space why the courts are only one tool. If you don't like qualified immunity, legislation may be the way to attack that. And I wonder whether we don't know why the court backed off, but if that's a piece of it, then makes that particular avenue all the more imperative. Good, keep trying. Well, maybe we'll turn to some statutory cases now.
Yeah,
Erin, go ahead.
sure. So we'll talk about a couple of them, and I think that these cases, in one level, they're statutory interpretation cases, but I think they each all kind of, have some other interesting things that are going on and tell us a little bit more about how the court thinks about some substantive issues. The first one I'll talk about is the Ruin versus United States from last term, which involved a provision of the Controlled Substances Act. So the Controlled Substances Act makes it a crime to accept as authorized for any person to knowingly or intentionally manufacture, distribute, or dispense a controlled substance. So, essentially, the default is it's a crime. If it's authorized, it's not a crime. And the question in this case was, if you have a doctor who prescribed the drugs, does the doctor have to kind of have knowingly, intentionally prescribed them outside the scope of the doctor's authority to prescribe, or just knowingly, intentionally prescribe the drugs in a manner that, as a matter of fact, happens to have been unauthorized? The court basically unanimously agreed that the doctor has to know or intend to have prescribed the drugs in an impermissible manner, but got there in 2 very different ways. The majority opinion came from Justice Breyer. And as it's not totally uncommon from a Justice Breyer opinion, it's a little bit less of kind of your traditional strict textual statutory interpretation decision. So the way that Justice Breyer got to that conclusion was by saying essentially that the statute says except as authorized, we're going to kind of treat the words knowingly or intentionally as modifying except as authorized to mean that you kind of have to knowingly and intentionally realize that it's not authorized. If you were staring at the text in front of you, like that's a little bit odd. I mean, if you even try and process, the idea of knowing and intentionally modifying the words except as authorized, like there's just sort of a grammatical mismatch there. And when you read the opinion, unsurprisingly, it doesn't actually start by really explaining why that makes like textual sense, and it kind of never explains why that makes textual sense. Instead, the opinion really starts with how there's a background principle that it's very important in criminal statutes to have mens rea. And really, it goes from the foundation of mens rea being kind of presumptively what you need in a criminal statute, and then goes on to say, that the presumption is even stronger when you have a statute that says that whatever the conduct is has to have been committed knowingly and intentionally. It's prior, so there's a little bit of kind of some policy thrown in about how this is all good. We don't really, we want to be sure doctors can prescribe in ways that they think is in the best interest of their patients. But really, the majority decision is predominantly, I think, grounded in just a background principle that is an extremely helpful background principle to see the court developing of that, that presumptively you do need some sort of kind of center in the context of a criminal statute. The dissent in the case, I guess it's actually a concurring opinion because they all agree on the bottom line. But so Justice Alito wrote separately in a concurring opinion that was joined by Justice Thomas and for the most part by Justice Barrett. And the opinion, what the lens through which he came at, which is also really interesting for thinking about how mens rea factors in, is he said, look, except as authorized is essentially an affirmative defense. It's not an element of the crime. The crime here is just knowingly and intentionally manufacturing, distributing, or dispensing the controlled substance. And when you're dealing with an affirmative defense, that presumption of a need for mens rea really doesn't fit in. The presumption comes on the side of the criminal conduct. So he says, this whole idea of trying to mush those concepts together is kind of very confusing. It doesn't really make textual sense, and it's kind of it's conflating the need for where you need the mens rea, which is the elements of the crime, as opposed to the affirmative defense, which is really more, a matter of something that the defendant has to come forward and focus on, and not something where we've traditionally imported the mens rea. And so he would have gotten to the same result, but got to that result by essentially looking through the statute to, if you go and look at what it says would make it authorized, one of those things is it being the doctor having prescribed the drugs. And he said historically, I would interpret those words to just mean that for that affirmative defense, it counts, even if the doctor, as long as the doctor did so in good faith, even if it was as a factual matter, the doctor was mistaken about whether the prescription was permissible. So I think it's really interesting. It's a decision that at one level is just a little bit about like how strictly textual you want to be, and a decision that came in Breyer's last term that maybe some people sign on to that are a little more textualist in some other contexts and all of that. But I do think even though you don't have kind of complete unanimity in how the court gets there, a takeaway to me is you do have all 9 of them kind of agreeing, like, look, it can't be right that the crime is committed if, like, the doctor fully thinks in good faith that they were prescribing drugs in a permissible manner, but they're just wrong. So everybody seemed pretty uncomfortable with that. They just kind of had a different way of getting to the same result.
Yeah, I think Ruin is a really interesting case, and the way I want to talk about it is, and transition to another case, is that to me it's like taps into this bigger theme at the court, because we spend so much time talking at the court about textualism, and in criminal law, textualism is not quite the same at the court. Now, many of us might say, well, that's as it should be. Like the rule of lenity and fair notice principles should put a thumb on the scale of the defense, so that, as the court put it years ago, speaking of history and tradition, years ago the court used to say, a federal statute has to be clear and unambiguous before somebody is prosecuted under it and convicted under it. But in more recent years, the court has curtailed quite dramatically, I think, and for some of us would say, unfortunately, the rule of lenity, that basic principle, and now try to kind of put it in a dark corner, where nobody can see, and only if it's just absolutely grievously ambiguous and nobody can figure out what in the world to do, which is to say hardly ever. But at the same time, what's interesting is, the court is sort of renouncing rule of lenity, but at the same time, they've figured out these other ways to construe criminal laws narrowly, and mens rea is one. The federalism canon is another. I think of Bond against the United States, where the court said that, we're not going to construe a federal statute to tread on traditional state prosecutorial authority unless Congress was clear. And then another canon, and I think maybe we can use the word canon, is what I think of as the overcriminalization canon, or the sweeping consequences canon, where the court has said, with some of the mail-in wire fraud decisions lately and in other spaces, we're not going to assume that Congress meant to dramatically extend the sweep of federal criminal law unless it did so expressly. And the most recent version of this was a case that, again, my clinic was lucky enough to be involved in, Van Buren against the United States, that dealt with the Computer Crime and Abuse Act, where the statute said that anyone who it's basically an anti-computer hacking statute at its core, and the language of the statute said anyone who accesses a computer without authorization, or here's the key language, exceeds authorized access, can be prosecuted and punished for a felony violation. And the issue in Van Buren was whether or not exceeding authorized access meant that you had access to some parts of the computer but not others. In other words, like a database that was off limits and you need to have a password to get in it, and you hacked into that password. That's what we said exceed authorized access was limited to. The government, however, took the view that exceeds authorized access meant a part of the computer to which you have access, but not for the purpose for which you used it. So if you broke the rules in accessing information on a computer, whether they be the website operator's rules, your employer's rules if you're on your employer's computer, or whatever else, then you violate the statute. And we represented a police officer who had access to a driver's license plate database through his work, but accessed it for personal reasons and was prosecuted for violating the CFAA. And we filed a brief in the court. This is one of these cases like Riley that so fun to work on with students. I mean, anything about the internet, you get in a room and you start to think about the consequences. So we had a brief filled with examples of what the government's argument would sweep in. So things like, using your computer using your work issued computer to shop on Amazon or to do personal email, or to fill out your March Madness pool. That, by the way, would be for commercial gain, so therefore you'd have an aggravated offense under the CFAA. Lying on a dating website in violation of the terms of service about your age or your height or the like. Or my favorite that the students came up with, using Westlaw for an unauthorized purchase. When you get a school issued password that says only for educational purposes and you use it for something else. It's important to sort of hit the clerks where they hurt, when you file a brief. And so we came up with all these examples, and we ended up winning the case 6-3, and Justice Barrett wrote the opinion, and she said, and two things I think are really important. She said, in addition to the textual analysis, which I'm sparing you right now, it turned on the two-letter word so. The definition of exceed authorized access talked about information so obtained, and so we had a huge fight over the word so. But Justice Barrett also noticed that the government's reading would sweep in a, quote, breathtaking amount of ordinary activity. And if you ask me which of those two things was doing the work in the case, I will tell you that oral argument contained about 50 questions about consequences and about 2 questions about the word so. And so I'm going to put my money on the former. And the kicker for this is, the kind of practice pointer. I think what's also interesting and tells you about the court is, the court said it is not an answer for the government to say, oh, we'd never prosecute those cases. The Chief Justice, I think, wrote this in the Stevens opinion years ago, and it keeps coming up where he says, just sort of trusting the government to use a statute responsibly is not an answer to an overbreadth type argument. And I think that's an important thing the court's telling us too.
Yeah, I do think, one thing, as where it can be helpful to practice across lots of different areas, but You kind of have to look at all of these cases through the lens of what's going on more broadly in the court's docket. And, in a sense, that's just like a variant of the major questions. And which last year the court in the West Virginia versus EPA case, in the context of, civil statutory interpretation, like really for the first time, full-throatedly embraced a major questions canon, the idea of we should think twice before reading statutes to kind of do extremely broad things that would have huge consequences because we don't lightly think that that's what Congress intended to do. And while it's been described less that way in the criminal context, I think it's really just very into the same theme, the same idea of we shouldn't just kind of look at statutes and assume, even though in reality we all know it's probably true, that Congress was trying to swallow up state authority, to criminalize all sorts of everyday conduct, to have all sorts of extremely to sort of empower federal prosecutors to be absolutely as creative as they can possibly be in bringing their charges. So I think drawing some of those interpretive pieces into criminal law, you really start to see these themes. And I'm going to talk a little bit about a case from last term, Wooden versus the United States, that I think has, you very much see the broader statutory interpretation and broader, in my mind, some broad issues that have nothing to do with criminal law kind of creeping into the way the court is thinking about statutory interpretation, even in the context of a criminal statute, and particularly in relation to the rule of lenity. So Wooden was a case about, it's an ACCA case, because you've always got to have an ACCA case in court, and it also involves being a felon in possession. Two of the statutes that are probably the greatest tools in the federal government's toolbox. But so the question here is essentially what ACCA says is that you have the violent felony or serious drug offenses. You have 3 prior violent felonies or serious drug offenses that are committed on occasions different from one another. The question in this case was whether occasions means like each criminal charge, or does it refer to whether all the criminal conduct was committed on what you would, in a common sense, would think of as a single occasion. So the facts here were an individual who, with 3 other guys, they broke into a storage locker facility, and then in the course of that incidents of burglary, went through and stole stuff from 10 different storage lockers, which resulted in 10 charges, and he pled guilty to all 10 charges. And the question was, do all 10 charges from that kind of single incidents that all happened in kind of one break-in count as a distinct violation, or does occasion really refer to was it a single occasion of criminal activity, no matter how many charges or kind of distinct criminal acts it may have produced? And this is another case where the court ended up agreeing unanimously that the answer is no, that's just a single occasion, not 10 occasions. But you have produced some really interesting decisions, just sort of about methodology and how you get there. So Justice Kagan's opinion for the court, principally the first part was just kind of a straight up textual analysis, just a plain understanding of ordinary understanding of the occasions. We just wouldn't talk about occasions in the sense of saying that 10 of the same thing that happened in the course of like 20 minutes are all separate occasions. In a normal way, you'd say he stole from 10. There was one occasion in which he stole from 10 different lockers. So that's sort of the bulk of the analysis. But then there's the second part of her opinion relied a decent amount on the fact that there had been a case at the Supreme Court a couple decades ago when this question had come up. And the Solicitor General at the time, the occasions language wasn't yet in the statute. And the Solicitor General nonetheless had confessed error and kind of taken the opposite position and said, even before the occasions language wasn't in the statute, the government didn't think the statute could be read to treat each single incident, each single charge as an ACCA violation. And shortly thereafter, Congress amended the statute to put the occasions language into it. And so there's a whole discussion in her opinion, basically, of kind of legislative and statutory history of the text is pretty clear, but it's like even clearer if you take into account that essentially this text was like put into the statute to resolve a debate that the Solicitor General had flagged over whether the statute should apply in the manner that the United States is now telling us it should apply, even though they used to think so obvious even before they had the text in there that it shouldn't apply to the defense error. So that's sort of the two prongs of her opinion, which end up producing, for one, a concurring opinion from Justice Barrett, who is like, I want no part of this discussion of legislative history and anything about the Solicitor General's brief, and just is like, I am on team text. So, I think to the extent there was like any doubt at this point about how she feels about legislative history, this case pretty much laid it to rest. But I actually thought the more interesting back and forth came in the opinions between, kind of back and forth concurring opinions between Justice Gorsuch and Justice Kavanaugh. Justice Gorsuch wrote a concurring opinion that was joined, I think in most part by Justice Sotomayor, right?
Yes.
Yeah. He would have resolved the case largely just on the rule of lenity. And he said, that this is all kind of messy because you don't exactly know how to figure out, like this is an easy case, but it's going to be hard to draw lines in lots of cases about what counts as an occasion, and offered a whole bunch of kind of difficult fact patterns and said, trying to figure all this out is sort of a mess. And we can just get there through ambiguity in the rule of lenity, and really advance, a bit of a historical discussion of the importance of the rule of lenity and how it should really come into play, kind of wherever you have some ambiguity in a statute, which like doesn't seem like super controversial as you're reading just his opinion. But Justice Kavanaugh then, prompted him to write separately and write a concurrence specifically directed to why, while he, believes in the rule of lenity and thinks it, it's correct and something that should apply, it should almost never apply, in his view, because statutes are almost never ambiguous. And basically, that's really like the whole point of his concurrence, is to say, when you apply all the statutory tools in the toolkit, like you should almost never end up with the kind of ambiguity you would need here. And so while certainly it's right to have a rule of lenity, there really should be very few, if any, cases where it's going to come into play. I think all of this has very little to do with the rule of lenity in criminal law, and is 100% a debate about Chevron and broader issues, and that the reason he wrote this opinion was to tell courts, like, even in this context, I'm not willing to budge an inch that might enable courts to have loose views of where statutes are ambiguous, because I know that for all, whatever good it might do here, it's just going to create trouble in the context I care more about, which is worrying about, letting courts quickly get to ambiguity and then reflexively defer to federal agencies on the meaning of all sorts of other statutes, in the context of Chevron deference. So I think this is, a great example of how, like, you gotta, it's always very helpful to have an understanding of everything that the court is thinking about, because sometimes there are principles, especially, but not just even in statutory interpretation cases. And it goes back to the point about text, history, and tradition as a methodology and the court's thinking constitutionally. You never know kind of what they're worried about, and it may be something that seems like it has nothing to do with this case or with the rule of lenity as a general matter, or I don't think it's animated at all by Justice Kavanaugh having a view that criminal statutes should be read super broadly. Like, I really think it's completely about the concern that even that if you want to be kind of a straight shooter about all of this, you can't say, well, like, the vast majority of the time we won't quickly get to ambiguity, but we'll quickly get to ambiguity when the rule of lenity is concerned, because we like that a little better. So to me, it's a really interesting look into some of the debate that has largely been going on between Justice Kavanaugh and Justice Gorsuch. I think they've been two of sort of the thought leaders about thinking about Chevron and how to deal with administrative agency overreach. And you very much see it creeping into the criminal statutory interpretation context here.
So that's a super interesting point, and I totally agree that it's critical to look across doctrines, look beyond criminal law, even in criminal cases. So that's a great example. Now, I would just say a couple things about Wooden. To me, it's just another one of these examples of, what I call lenity is dead, long live lenity. Justice Alito said at oral argument, is like, occasions this is such an impossible case. I'm paraphrasing here, but he said something to the effect of, this is an impossible case because the word is so flimsy, it can mean anything. And I think you're just not going personally, you're not going to convince me that the word is absolutely clear. But the court is loath to, a majority of the court is loath to name what they're doing on some level, let alone why. And I guess my only 2 cents, and I think Erin, there's certainly a lot to what you say. I do think there might be one element of it that is criminal law focused, which is I think there's also a hesitation on some justices to give energy to the rule of lenity because they really realize from their own experience how poorly so much of the federal criminal code is written and how vague and open-ended so many pieces of critical federal laws are. And so if they let that horse out of the barn, maybe they're just afraid and they want to have a little more control over that. The other thing I would underscore about Wooden ties back to Van Buren a little bit is just, it's interesting how the court's shifting methodology changes the way we practice law, right? I mean, I remember when I was a law student and being trained to research legislative history, I was like terrified that I was never going to find all the right stuff, that this seems so hard. Well, it turns out that's not important anymore. What's really important is to sit down and think about the ordinary meaning of a word, the consequences of interpreting a statute a particular way, and the conduct that can be swept up. And so however you do that work, if you stare at the ceiling, if you're like me and you like walk, you like to think while you walk, this is the time we can take a jog or a walk. I mean, I tell my students, when we sit together and brainstorm, the stuff we're all hearing now, like what's the office good for? I mean, apparently one thing the office is good for, the research tells us, is brainstorming and creative thinking. Well, that's how a lot of this work is going to get done. So that's my pitch for going to the office. Go down and talk to your colleagues about, well, if the government's right that occasions means every single thing, like let's come up with some examples. And that may be the thing that wins the case, right? Not some piece of research.
It is a little remarkable when you read the opinion for the court, Justice Kagan's opinion. I mean, like a bunch of like the analysis is basically just clearly like she and her law clerks sat around thinking of creative ways to explain why, in common parlance, you wouldn't call something, what you would call an occasion. I mean, and it's a great read, and you're like, yeah, that makes sense. But you're also, there's a little part of me that's like, wait, this is law. So it's just it's a little bit different way.
It's spitballing interpretation, yeah.
But that is once you're in a plain text world, like it is supposed to be intuitive or common sense, as where we get accused of saying in every brief we ever file.
I know, yeah. I remember when I was clerking, a little aside before I tell that we turn to the next case. When I was clerking, I talked to one of my friends who was clerking for Justice Scalia, and I said, how does Justice Scalia prepare for a case? Like, I just imagine him like having the U.S. code, not the U.S. code annotated, just the U.S. code, like on his desk, just staring at it. Like, is that what he does? He goes, yeah, that's what he does. So maybe we should all do more of that. Well, we do want to mention a couple of the cases before we turn to a little bit of Q&A that are on the court's docket for this term. And the case that I want to highlight is called Jones against Haydick. So the court does have sort of a light load so far in the criminal law realm, but a couple of cases that are definitely noteworthy. So Jones against Haydick picks up on Rahafe against the United States, which is a predecessor to the Ruan case, where the court has sort of re-energized the mens rea doctrine. And the court held that the felon in possession statute requires knowledge, not just of the possession of the gun, but of the restricted status for possessing the gun. So the most commonly that means you're having been convicted of a felony. And so naturally, when the court does something like that, then we turn to habeas type litigation, and retroactive relief is a question. And so this case flows out of that. So the interesting thing about Rahafe is that when the court decided that case, no court of appeals had decided that mens rea attached to the status designation under the statute. And so every defendant in every court of appeals had been up against circuit precedent for years, telling judges no need to make it a jury instruction on this, no need to make a finding on it, all the rest. And so Jones is just one of many, many people who now is coming back into court saying, wait a minute, I was convicted under the statute without the mens rea. And so he's a federal prisoner. And as I'm sure most of you in the room know, we don't, strictly speaking, have habeas corpus in the federal courts. At least in the main, what we have is a motion under Section 2255, which substitutes for the writ of habeas corpus and allows somebody to seek relief based on the same kinds of things that traditionally you could seek relief for habeas. But there's a savings clause in Section 2255 that says that you are allowed to bring a traditional habeas petition in federal court as a federal prisoner if the Section 2255 motion is, quote, inadequate or ineffective to test the legality of your detention. So that's the key language. Inadequate or ineffective is inadequate or ineffective to test the legality of his detention. And so what in EDPA, the court quite dramatically restricted successive habeas petitions and successive habeas motions under Section 2255, so that if you want to bring a constitutional claim, it has to be based on a rule the court has made retroactive, or if you want to bring a case based on new evidence, you're allowed to do that under certain circumstances. But the one thing you're not allowed to do is bring a successive claim based on a statutory claim. And rehafe is a purely statutory decision. And so what Mr. Jones says is, look, I have no avenue at all to bring a Section 2255 motion because I don't have a constitutional claim and I don't have a new evidence claim. I have a pure statutory claim. So therefore, Section 2255 is inadequate or ineffective to test the legality of my detention. And so he says, I'm entitled to a hearing and ultimately habeas relief because I didn't have knowledge of my felon status and therefore I'm in prison for something that isn't a crime. The Eighth Circuit rejected that argument and said, no. There's nothing inadequate or ineffective about Section 2255. Even though Eighth Circuit precedent was dead against you at your trial and when you filed your first 2255, you could still raise this claim. You just would have lost. Or maybe you could have sought en banc or even the Supreme Court to take a look at it. But you had an avenue. And so it's not like it was inadequate or ineffective, it's just that you would lose. And indeed, letting you do that now would just be an end run around the restrictions that EDPA has laid in. But Jones's response is kind of twofold, again, focusing on the text as we do these days. He first says, well, you can't say it was effective when the Eighth Circuit had the wrong rule. And the analogy he says is like giving a student a test and using the wrong answer key to grade the test is not an effective way to test somebody's knowledge. And secondly, he says, your two-letter words is one of the themes for today. The word is critical in the statute. What the Eighth Circuit said is 2255 was an effective way, but right now it's not. You can't even bring a 2255 now. So he says is a present tense word, and if I can say right now it's ineffective or inadequate, that's good enough to get me into court. The objection that naturally raises is, well, wait a minute, that would just be a total end run around EDPA. And the response that Mr. Jones has, which I happen to think is a pretty good one, is no, I'm not saying anytime you're boxed out of successive petition rules, you get to go running to 2241 and bring a traditional habeas petition. It's only when you're testing, quote, the legality of your detention, which is actually a quite narrow phrase, which means, as I would put it in common language, I'm in prison for something that isn't a crime. Or perhaps I'm in prison for longer than the statute allows. But that's the legality of your detention, not I was convicted in violation of some procedural rule, et cetera, which is the bread and butter of habeas these days. So it's actually, I think, a narrow savings clause. The federal government has actually said that they agree with Jones. That after speaking of shifting positions, you mentioned another case, the government has ping-ponged on this issue for years, but has now filed agreeing with Mr. Jones on the basics, but trying to set up a higher threshold showing that's required to get in the door than Mr. Jones would have. So there's some disagreement on the back end as applied to his particular case. So the court appointed an amicus to argue in favor of the Eighth Circuit rule, which interestingly, and this is the last thing I'll say, and I'm curious if Erin has thoughts on this, the Eighth Circuit rule, interestingly, is in line with 10th Circuit precedent written by then Judge Gorsuch, taking a plain language approach, which I don't think actually is the better plain language reading of the statute, but nevertheless, Judge Gorsuch then at least said that he thought the plain language prohibited a claim like this. So with Justice Gorsuch off the table, this could be a challenging case for Mr. Jones, but I think that's a really fascinating case with a lot going on.
Yeah, no, I thought the government's position was interesting. I mean, as I understand it, they're basically like, look, you should be, this should be an avenue, but essentially you should need to be able to prove you were actually innocent. And they want like a harmless error analysis built into it, which I could see like some of the court thinking that seems sensible because the Eighth Circuit's rule just seems very counterintuitive. But I also think at the same time you have a number of members of the court who are going to think like, well, this is habeas, you got to have some limits here, and there's a difference between somebody who's able to say like, I really didn't commit what was actually the crime I was convicted of, and somebody who's seems like they're getting off on a technicality because the pleading requirements were different at the time. Because the government will always be able to come back with its own force of saying, well, if we'd known that was the law, it would have been super easy to prove that this guy still committed the crime. And with this court, I think there's some members who still have a little bit of that reaction to it. But whether that actually kind of comports with like a textual understanding of it as opposed to just a sort of, this feels a little bit like the fair resolution to some justices, we shall see.
You want to do our white collar?
Yeah, I'll talk a little bit about the white collar cases just before we then take some questions. Because I do think the court has a couple of related white collar cases up that are quite interesting, especially if you kind of follow the whole line of McNally's, Skilling, all of what the court has done in this area. They're distinct cases, but they both arise out of like a single very large investigation into various alleged pay-to-play practices involving Governor Cuomo's administration. But there's actually like an even overlapping parties among the two cases, but they are distinct prosecutions that actually present completely distinct questions in the context of different cases. But you might get confused if you pull up the briefs because there's like two briefs by the same person, two different cases. But anyway, for those of you who need a brief refresher, for decades, we had the courts that had sort of read honest services fraud into the mail-in wire fraud statutes. And then back in McNally in the 1980s, the court interpreted the statute to not allow for honest services fraud. And Congress then quickly amended the statute and put honest services fraud back into the wire and mail fraud statutes. And then we had about like 20 years of courts having no idea how to figure out what was honest services fraud, and got to the 2010 decision of Skilling that went before the Supreme Court, in which the argument was made that the whole concept of honest services fraud was just was impossibly vague and the statute was unconstitutional. And Skilling ended up, a majority of the court thought that the statute raised serious vagueness issues, but and three justices would have just held the statute on the provision unconstitutional. But the majority of the court ended up putting kind of a saving gloss on what it viewed to be honest services fraud, concluding that in order to have honest services fraud, the government has to prove that someone took bribes or kickbacks in violation of a fiduciary duty. So you have two sets of prosecutions here that kind of involve like facts that are just a little removed from how you'd think about what traditionally is covered by the statutes, in part because they both involve theories that sort of came into being before Skilling. So the first is the Percoco case, which is a case that arises out of allegations that parties were paying Joseph Percoco, who was at times a high-ranking member of Cuomo's administration, bribes in order to get political favors. But the complication in the case is, at the time he was getting these payments, he was not part of the administration. He had stepped out of his job in the administration and was serving as Cuomo's campaign manager. And so he argues, look, I was not a government official. I had no fiduciary duties. So I was a lobbyist, and it is not a crime to accept money to serve in a role as a lobbyist, to try to use your political influence to get political, to help your clients get things out of the government. The government nonetheless prosecuted him, and invoking this case from before Skilling, in which the Second Circuit had said that essentially, if you're kind of close enough and have enough influence over the government, we'll treat you as if you were a government official and as if you had a fiduciary duty, and say that you can be convicted of honest services fraud for accepting money. And so the question that's presented in the case is essentially, can a private party who is not a government official be convicted of honest services fraud on the theory that they nonetheless owe that the fiduciary duty they violated is a fiduciary duty to the public. Which seems like a little bit of a strain with a court that is already very suspicious of the entire world of kind of honest services fraud, but we shall see. The second case, the Simonelli case, involves a same individual paying different people some money to allegedly get political favors out of them. But what you have is basically there was a big grant program where the state had given a nonprofit organization money that it would give out on the state's behalf. And the allegation is that a private party, some of the private parties who were hoping to get the funds, used their influence and improper money and whatever it may be to get the nonprofit to kind of structure the grant program such that they would likely get the grants. And so they are being prosecuted not on honest services fraud theory, but on the theory that they defrauded the government, they defrauded these parties. But the complication in this case is the government doesn't claim and didn't try to prove that like it wouldn't have given them the business anyway, or that there was somebody who would have done better work cheaper, or that really there was sort of any injury that was suffered on sort of the back end by virtue of the criminal defendants here having gotten the work. Instead, their theory is that by depriving the nonprofit that was handing out the grants of potentially valuable economic information that it would consider valuable in deciding how to use its assets, they deprived that nonprofit of the intangible right to control the use of its assets. So what we have here is a theory that you have a property interest in having information that would be important to you in deciding what to do with your assets, even if you're never deprived of the assets themselves. This is another Second Circuit theory that was kind of crafted at a time when skilling was not the law, and actually at a time when there wasn't even, it was like in a very brief moment in time when there was no honest services fraud theory at all. And it kind of went away, and the government has resuscitated it in the wake of skilling to basically bring a lot of prosecutions that look a heck of a lot like exactly what skilling was saying you're not supposed to be prosecuting for anymore. So I think these are, in my mind, they both look a lot like kind of cleanup cases that are saying that are being taken to say, hey, sort of SDNY and Second Circuit and all of you up in New York, like, we actually meant it, and stop trying to find clever, creative ways to bring exactly the type of cases that we keep taking cases to say you cannot prosecute under the mail and wire fraud statutes. So we'll see, but that they certainly have that flavor to me.
Interesting. Well, in lieu of my adding any further thoughts, we'll hand it over to Shana and see if there are a question or two.
Not believe we have almost run out of time, but I know these two have to go, and so do you probably. So we're going to do some Q&A. People can just raise their hands when they're ready. And in the meantime, they can grab some water, which I'm sure they need. I did want to mention that, the case that Erin was talking about, U.S. Wooden versus United States, the one where the question was whether someone who breaks into a storage locker, 10 different storage lockers at the same time, is that an occasion or 10 occasions for purposes of ACCA prosecution, which, quadrupled the person's imprisonment. I want to point out the brief facts in that case, which is Mr. Wooden, when he broke into those storage units, it was 17 years later that he was being prosecuted for being a felon in possession. And why? What were the circumstances of that particular prosecution? A police officer had shown up at his door on a cold, wintry, wet evening and asked to speak to his wife. Mr. Wooden said, "Oh, I'll have to go get her and bring her to the door." The police officer said, "It's so cold outside. Would you mind if I came in?" And Mr. Wooden said, "Of course, sir," and let him in. And then the police officer saw a shotgun sitting inside the door. And that is how Mr. Wooden was prosecuted 17 years later under ACCA for another 20-year sentence for being a felon in possession. It's that kind of tidbit that you'll find in our brief guide to SCOTUS's criminal law stuff. Safe on those flash drives. So that's why you want to read it. All right, questions?
Hi, David Jimenez, Prison Fellowship. Obviously, this session we saw just across the board that there's very different conservative majority weightings of the importance of stare decisis and how much precedent they're willing to overturn. So I'd be curious if you think that the growing, I wouldn't say indifference, but the lower rating of deference and prior decisions of the past could actually lead to a lot of the Warren Court legacy being overruled or pulled back, as opposed to maybe not as expanded as widely as many people would like to see here.
Do you want to do your legitimacy thing? You said it.
Sorry.
Well, I'll give a quick answer. I think Erin and I were talking yesterday, and she had some interesting thoughts about the new way the court is thinking about legitimacy as it ties into stare decisis. So I'll let Erin share that thought. But just a quick little nutshell from me is that, at the Vega argument, I think what Justice Kavanaugh said to the lawyer asking for Miranda to be applied there was, why isn't the answer when we see a case like this to accept it, but don't extend it? Miranda's about as controversial as it gets, about as core in the Warren Court era as it gets. And so if we think about that being the approach to Miranda, maybe the exclusionary rule, maybe certain Eighth Amendment principles, like I think the life without parole line of cases, I think is another one that has just sort of stopped dead in its tracks. And probably I think what we're going to see is the court just content to leave those cases where they are and not extend them an inch, because I think my guess is the court has other areas where they're more invested in overruling precedent. And I think the court, even though it's a more aggressive court in some ways, I think the court still has this feeling like we have kind of an overruling budget every term, and there's only so many monopoly chips we have or whatever, to spend. And I think those criminal law cases probably are unlikely to be the ones that they spend the most energy on. But there's things I could be forgetting.
I think that's right. I do think some of it is a matter of just kind of what gets there, because, and it's why it matters that the cert process and sort of the pace of issues getting there and how things get teed up makes such a difference. Because I do think this is a court that, for a while we had a court that I think at least sort of the center of the court was viewing the legitimacy of the court through the lens of moving slowly and being careful about what we overrule, and kind of, stare decisis itself being a really important component in how we think about the legitimacy of the court. I think there's at least, a significant number of justices on the court now who don't think about, who have a very different conception of legitimacy, and think of the legitimacy of the court coming from having a consistent methodological process, having, getting the right results, getting the results that in their mind are correct constitutionally. And so if the issues get there, if that's how you think about it, it becomes a lot harder. You have a lot more, Justice Thomas-like opinions of people who are going to say, I can't sign on to something that I don't think is legitimate because I think that's what undermines this institution. So I do think a lot of it is, if it's before that, there's some members of the court that are going to have a hard time just kind of going along with some things that they don't think are right. And a lot of it becomes a matter of making, being thoughtful then about what issues, whether you're out there kind of wanting things overruled, or you're out there wanting to preserve things, being thoughtful about the way you get things to the court and the way you kind of try to avoid getting things to the court.
Mm-hmm.
Other questions? There we go. Robert Holt.
Hi there, Robert Alt, the Buckeye Institute. So I'm going to ask an unfair question about a case that's pending for cert before the court. Just curious if you've got thoughts on it, which was triggered by the discussion about the rule of lenity and possibly Chevron and the interrelation. So there's been a number of cases percolating up on the bump stock issue, whether or not a bump stock constitutes a machine gun, and whether, one, does Chevron deference apply to statutes that have both civil and criminal elements to them, and the rule of lenity. So there's a case which went en banc in the Sixth Circuit that's up. I think there's another case that's percolating up. Chance that the court would hear that. Any thoughts on that? Because given what you're saying, I think that could be a really interesting view.
I think the issue is one the court, the legal issue, particularly the issue of Chevron applying in the context of deference for criminal statutes, absolutely something this court's going to want to get its hands on. I'm a little, I'd be a little surprised if they want to get their hands on it in the context of bump stocks. I think there's some real problems with I think there are some real legal problems in these bump stock cases, and that anybody who can divorce them from the fact that they're bump stock cases would see that. But that is the elephant in the room on it.
Yeah, I'll just say I think there is also another question, I think a related question you're putting your finger on, about what happens when you have a statute that has both criminal and civil applications, and can you apply Chevron to a statute like that, even if it's in the civil context, realizing that whatever you say the statute means is ultimately going to be carried over to the criminal side. I had a case called Esquivel Quintana about 5 terms ago that actually had this issue in the case, and we briefed it pretty hard, and the court was very interested in an argument, and you will not find a single word about how to resolve it in the opinion. The court ducked it, but I think that the new membership, in line with some of the other projects they have, may well revisit it, because I think that's a really great place to start in curbing Chevron.
Yeah, and I think there's a real opportunity in the right case to get there through white collar. I mean, that comes up a lot in the context of sort of SEC things and all of that. That's where you have a lot of overlap in a way where the court already thinks there's some civil overreach. And if you can kind of get there in a context where it's criminal, or you point that out, I think that brings together 2 instincts that this court has, and could be just a very good context in which to get law that will have much broader implications than in a context that might, help them get to the right result.
Thank you, Jeff and Erin. You are both national treasures, and I'm so incredibly grateful for the fact that you two share your time and your talents with us. And everyone in the room, I think, thanks you as well.